Hello, everyone. I want to welcome you all back, and I hope you had a great weekend. Um, Please forgive the construction noise in the background. They're doing construction outside of our office, so I don't really have much to say other than you probably hear a bunch of banging and loud noises, but try and overlook it if you can. All right, so let's go ahead and start talking about. First off, this lecture is really going to be focusing in on the legal brief itself, but it's also given us an opportunity to speak a little bit about an overview of the United States legal system. I'll be posting really three different lectures this week. This one will be dealing with how to write a legal brief, but I'm actually weaving in content so you can kind of get, two for the price of one with this. All right, so I want to do these separately so you can get an understanding of it. I also want you to practice and work on the legal brief first, and then this lecture should also help you in a lot of ways to rope in an answer to the discussion questions for the week. All right, so let's go ahead and get into it. So a lot of people don't realize this, but the government has had a very interesting role in kind of crafting a lot of terms and a lot of components that deal with health. Health in itself was categorized by the World Health Organization in 1948 as the complete mental, physical, and social well-being. It's not merely the absence of disease. Longest also talked about health and how, and really Longest had a model where he conceptualized health as being something that could be considered a shift in the physical, psychological, and economic state of people. Hence, a strong government interest in state and definition of health. So it kind of gives you an idea that when it comes to health and also health care, there's certainly an interest in the government to surface there. Right? There's an interest in the government to want to be a part of this, not only development, but the sustaining of healthcare. But it also tells us that the government cares because it impacts the bottom line of a nation. All right? So when we think about the idea of illness, defined by the law or defined by lay people, what does illness really mean? So illness. So I kind of created my own little formula here because I see it as a formula. Whereas health, so it's a natural function, what you are naturally, what you are when it regards to your daily being. If you were born with no legs, it doesn't mean your health is better or worse than mine. It just means in a lot of ways you lose a certain capacity. Your capacity doesn't compare, I should say, to my capacity as it regards to walking, but everything else may be completely normal and true. So whatever the health is, natural function, minus illness equals your function. So the legal definition attempts to delineate illness from health, sets a baseline for normal function, and this legal definition socially constructs deviance, which enacts what we call the sick role. Okay, so I want you to think about that. Now, this idea of how the law shapes the idea of illness sets up really what you should normally be, so a baseline for normal function, but it also creates a set of check downs, if you will, when somebody is sick, what they should be doing. So the first thing to note is this idea of the sick role, right? So when you think about the sick role, it refers to an abdication of one's health and deferral of recovery to the healthcare system. So basically, when somebody's care in itself can't be taken of their own volition, they have to go and outsource it or defer to the healthcare system. So the pillars of the sick role, that this was created by Talcott Parsons. And Parsons believed that ill people are not responsible for the condition. Subsequently, they can't fix it. So you didn't make yourself sick, therefore you can't fix it, right? So when it comes to something dealing with flu and cold and stuff like that, obviously you can fix those things. But if you break a leg, you can't fix that, right? So given that, it's proportionate to their severity, right? An ill person is exempt from normal personal and social obligations. So if we know you're sick, if we know you're on chemo, we know that you're on dialysis, it's understood that there's some things that you can't do and we don't expect you to do, and we're going to actually give you a break from doing those things. So that's how we kind of socially present ourselves. Then next, we talk about the role and the idea that sick people are expected to get care. So you can't get off the hook from your social and personal obligations and then don't go get health care, right? you can't say, oh my gosh, I just feel so horrible. I think I'm going to just stay in, stay home, not go to work, not take care of family, not do anything. Because people are expecting you to at least go get a diagnosis, right? And then finally, once you go to get health care, sick people are expected to get care from professionals. And here's an important one: comply with the treatment advice. So remember that. We're going to talk about the sick role in context of race and ethnicity and things like that, because again, these things are important. And understand that the sick role in itself is a function of this next component and next piece that we really want to hit on. Is like how we've socially constructed these things, right? So a lot of things are socially constructed, not just race and not just gender roles, but sickness, health, socially constructed. So we want to show you how the law has done this. In health law, there is an amazing opportunity to see how the law got itself involved in the development of health, and particularly the development of illness in this case. So we find Katsky v. Blue Cross Blue Shield of Nebraska. This is a 1994 Supreme Court of Nebraska case, and you can see the official notation and the correct notation of this case listed right below the double lines. But the thing that I want you to do, this is about writing a legal brief, right? So what I'm going to do is kind of walk you through some of the language and some of the ways you can approach these things with the legal brief. And then from there, this will give you an idea how to construct your Macon v. State legal brief. There'll be some nuanced differences because this is definitely a more contemporary case relative to Macon v. State. Obviously, there's a lot of years have passed since Macon v. State happened. But there are also going to be some truncations that you'll see. So I won't necessarily hit on every piece that's in your legal brief guide that I provided on Canvas. So I want you to also make sure, as you go through what we're talking about right now, make sure that you have in front of you a copy of the How to Write a Legal Brief guide that I posted in Canvas, okay? So now let's go ahead and look at it. So what we find is that Cindy Katsky sued Blue Cross Blue Shield of Nebraska for breach of contract and sought to recover, listen to this, $6,022.57. So effectively what happened, here the fact pattern or background of this, okay? So in January 1990, her gynecologist consulted with another physician regarding her aggressive history of breast and ovarian cancer and her current health given this history. And basically the doctors said, listen, given what we know about her, we think, number one, that we should start thinking about removing the uterus, removing the ovaries, and fallopian tubes to save her life. This is life and death. We know that cancer is certainly one that is a disease that has some family ties to it, and we need to be thinking about that. And I think the best way to save her life, according to Dr. Lynch, was to remove the uterus, ovaries, and fallopian tubes, right? So from that, Katsky agreed to have the surgery, and Blue Cross Blue Shield of Nebraska denied the payment initially, indicating that they might pay for the surgery. And then Blue Cross Blue Shield of Nebraska cited this idea in their policy or contract and defined illness or bodily disorder broadly. Hence, they had a level of ambiguity in that policy, right? So what they were basically saying is that illness or bodily disorder could cause or would be a acceptable form or way to get your service or procedure approved. So what was happening is that we found people were saying, hey, listen, I've got an illness, I got a bodily disorder, and I need to get some kind of procedure to take care of it. But Blue Cross Blue Shield of Nebraska did not define what that illness or bodily disorder was, right? So, this had to go before the courts. Blue Cross Blue Shield of Nebraska argued the appellant did not suffer from an illness. They effectively said that Ms. Katsky comes in, she says, I've had a history of cancer, take out everything. And that in itself doesn't constitute illness. That simply constitutes, in some ways, like they were saying, fear. That constitutes the fact that, listen, look, nothing happened. Why are we paying for something that didn't happen, right? And then the appellant comes back and says, well, listen, this is about the predisposition to an illness, cancer for the sake of the case. And Dr. Lynch labeled the surgery as a prophylactic or preventative surgery, right? So Blue Cross Blue Shield of Nebraska went through and lost the very first time at the lesser court. So then they appealed it within their district court, but we'll get to that in a second because we're still in the fact pattern. So they filed a summary judgment in this case. So I'm going to talk a lot about summary judgment when we do the anatomy of the legal system lecture for you. But to give you a quick and dirty of what the summary judgment is, imagine summary judgment as basically all sides, so both sides, both the plaintiff and defendant, come in, they do their evidence, which is what they call a discovery. So they have all the evidence, they got everything they think they need to go to trial. And basically they're saying, you know what, we don't even need to go to trial. I think what we found is so compelling. It is so compelling that we don't even need to waste any more money. I think everybody should show the judge what we have and let the judge decide right now on an issue before it goes to trial. That way everybody saves money. And if we have sufficient evidence and sufficient discovery evidence particularly to show that we don't even need to go any further, then the judge can determine through a summary judgment whether an issue or a case can go without going to trial, and we can go ahead and decide on it. So they filed for that and subsequently lost. So the Supreme Court of Nebraska in 1994 continues to talk and look at this other idea of Blue Cross Blue Shield of Nebraska's contention that a policy covers medical necessity, right? Getting into the nuts and bolts of this. So we're still talking fact pattern, still talking background. Medical necessity, what is that? Well, it's defined as the services, procedure, drugs, supplies, durable medical equipment provided by physician, hospital, or other healthcare provider in the diagnosis or treatment of covered persons' illnesses, injury, or pregnancy, which are appropriate for the symptoms and diagnosis of the patient's illness, injury, or pregnancy, provided in the most appropriate setting and the most appropriate level of services, consistent with the standards of good medical practices in the medical community of Nebraska. So that is a good, now when you guys are doing your legal briefs, you may want to define some of those terms. Now, most of the time you wouldn't define that in your fact pattern, but I did that because, quite frankly, we ain't in law school, so I know that you guys don't know a lot of this stuff about medical necessity and so on and so forth. But it's good to put this in here because this is crucial to their case. So now we get to the issue. So the issue here is whether the appellant's condition constitutes illness, right? So whenever you present an issue, you then go to your holdings. So this is what you believe, right? So you're writing a brief based on your position. You give an answer and you say yes. And then the reason why we're saying yes here is that cancer or the prospect of cancer can be a predisposing condition for a person, right? So let's look at the applicable rule of law. The applicable rule of law is talking about the given construction of the policy, which is really, this is a contract issue. This is simply a cut and dry contract issue. And given the construction of the policy, medical necessity is not clearly defined, and certainly we know that the idea of illness wasn't clearly defined. Hence, this is a breach of contract. So this goes before the Supreme Court in 1994, and I want you to think about something. This service was not provided primarily for the convenience of any of the following. So this is something to keep in mind. The covered person, the physician, the covered person's family, the person or healthcare provider. And it's not considered, when thinking about necessity, not considered to be unnecessarily repetitive when performed in combination with other diagnoses or treatment procedures. So when we think about that, we're saying, okay, So I know the issue. What are the holdings? Okay, I think yes. I think this is definitely. I agree that this is a predisposition issue, and they should cover it. Um, but one critical thing to keep in mind is that this was not done at a convenience for anybody. So it's not basically something that's being done um, to benefit anybody other than somebody's health. Okay, but it's also not repetitive. So a lot of times, what will happen is you'll get an MRI, for instance, at one doctor. Then you get another MRI at another doctor, then another doctor. So you got 5 MRIs in a 2-week process, and the insurance company's only going to cover one. Right? You can't come back and sue and say, I want you guys to cover the other 4, because they're going to say, listen, unless it was a different body part, this is repetitive and it's unnecessary. Okay? So here are the procedural histories of this case. So it goes to district court, granted the motion, and found the policy did not cover the appellant surgery. Listen to this. So that means Blue Cross Blue Shield won initially. Katsky filed a notice of appeal, and the case was removed to the Nebraska Supreme Court. So they use all this confusing old 16th century language to basically say that the case ended up going to the Nebraska Supreme Court. So district court said, nah, this policy shouldn't have been covered. The lesser court, so the lower court beyond the district, below the district court, said yes. So Katsky won, then Katsky lost an appeal, and now Katsky's back at the Supreme Court. So this is what they said. So here's my yes, but in the present case, the medical evidence regarding the nature of breast ovarian carcinoma syndrome persuades us that the appellant suffered from bodily disorder or disease and thus suffered from an illness as defined by the insurance policy. All right, so now let's get into what actually happened. So the court now, here's the court's order, and I should have moved the court order point up one. So this second bullet on this slide actually fits the court's order. All right. So court's order says Blue Cross Blue Shield of North Carolina is not entitled to judgment as a matter of law. Moreover, we find the appellant's condition did constitute an illness within the meaning of the policy. So what the court did is they reversed the decision of the district court and remanded, remanded the cause to further proceedings. So all this means is they sided in favor of Katsky. Blue Cross lost. And now they got to figure out what to do. So the remand with cause is basically trying to figure out what are the remediation steps, okay? So let's get into the nuts and bolts of this legal writing brief issue, or legal brief writing issue. So the most important thing I want you to remember is that this is about concise and clear summary of a case or legal issue. You are not writing a book, but you're also not sending somebody a bunch of bullets, okay? Sometimes, in some cases, particularly those that don't have a historical latent to them, the cases we'll be doing usually can follow bullet 3. But typically, if you guys go into law school, there'll be some elements that you have to do the bullet 3 issue. And then there's some that are just basically real quick and dirty, where all you need to talk about are the facts, issue, answer, and reasoning. Okay, so that can be sufficient in some cases. So I don't want you guys thinking that legal brief writing is a standard, okay? I set a standard for our class, obviously, so that you guys can know what you're going to be graded on. But I also set this standard so that you all can have a better understanding. So if we do the short version or the truncated version here on bullet 2, you really aren't getting like the best bang for your buck as it comes to remembering what we're doing. So I like you to do bullet 3 because that way it gives you a full scope of what's going on. Even if you don't have but a sentence or 2 in some cases, it's okay. All right. So follow the legal brief guide that I have in Canvas. Please follow that guide. You should have that guide up with you right now. Outline each section that's provided in the brief. Do everything I told you to do in the brief. Don't skip any sections. There's no reason for you to skip a section, okay? There are a lot of times where I've done this brief, and many didn't understand this concept of procedural history. So refer to the legal guide, and I have Sakai this in Canvas. So make sure you refer to that. So I've taught this class quite a bit. I've taught this class a lot. And the thing that I notice when it comes to people writing their legal brief, they don't understand the procedural history part. So if they tell you what the procedural history is, great. If they don't have a procedural history, just say that there's none noted, okay? And I'm okay with that. I'm perfectly okay with that. Because some of these cases will be a first, okay? So I don't understand that. But a lot of the cases should have a procedural history because it's an appellate case. So which means it's already been to court at least one time somewhere else. The holding should be the answer, should answer the question posing the issue. Okay, so you're basically saying, the issue is, whether the the appellant had an illness, and your holding should say yes, the appellant had an illness and given blah 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 blah. So this is where if you took a side, you're saying yes, they had an illness. This is why, and this is what's going to happen. This is what we think is going to go down. Your facts and reasoning are where your biggest points come from. And the thing I want you to understand is that be detailed and exhaustive of those relevant pieces. Write a big and relevant paragraph for these sections. There's no reason for you to hold up there. Let it loose. You know what I'm saying? Like, you only have a page. You really need to be identifying and outlining. You need to understand the facts and the reasoning of it, okay? Full names upon the first sentence or first reference. No contractions in academic writing. This isn't applicable necessarily for the assignment that you all will do this go round, but I know it will be for a couple more. But always capitalize the 13th and 14th Amendments, okay? 14th, 15th, any amendments, capitalize them, okay? It's not lowercase 13th, and it's not the number. And this is our last slide here. If you mention the 13th or 14th Amendment in the issue, then define it in the rule of law. The reason why I'm saying that is because I want you to really understand what those things are, okay? And we're going to go over those. You're going to really learn those things. But I want you to learn them well, because that's something that if any of you are ever as a practitioner being sued for anything dealing with discrimination, typically you're going to be sued based on the 14th Amendment. So I want you to know that and understand that so you can already shut it down if somebody comes in crazy. All right? And as a lawyer, as civil rights lawyer, for those of you that want to go to law school, hey, let me tell you something. This is going to help you out immensely learning these things now. And the issue should be in the form of a question or begin with whether, okay? So it should definitely be in the form of a question, or it can begin with to determine whether blah, 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 okay? Or whether blah, 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 blah. So you see that example in the slides that I presented a second ago. Quote the court's words in the holding and reasoning sections if you can, okay? Sometimes, and by the court, meaning if the judge or justice has said something, it's okay to quote them there if you want. And you won't really have to worry about this because I'm not giving you any cases. Like in previous classes, I had my students brief Plessy versus Ferguson. You all won't do that in this class because honestly, they're all on the internet. But basically, I had a whole bunch of people turning in stuff from the internet thinking I wouldn't figure it out. And that's just stupid. All right, so those are all the things that we have for the legal brief writing. I really want you to go through this lecture, soak it in, understand it, know it, feel it, believe it, all that good stuff. Because the next lecture that I'll give you will kind of give you a legal overview of our legal system, and then we'll actually get into the Chasing the Boogeyman module, okay? Now, the reason why I'm stepping this, I'm giving you these supplemental lectures, is because I need you to have these understandings of what the law means so that when we start talking about the injustices, you'll actually understand legally how they actually broach rights, okay? Thanks a lot, and we'll see you soon.